Welcome to the State of the Market for Law Firm Sales in 7 minutes. My name is Jeremy Poock, and I lead Senior Attorney Match. In today's In 7 minutes, we'll present the first of a three-part series on the three checklists to review before selling a law practice. So let's jump right into it. The first checklist relates to the logistics involved with selling a law practice. And the first item on the checklist is how to value a law practice. When it comes to valuing a law practice, there are five components to value. And those five components are the client list, the referral source list. Taken together, that's the proverbial book of business that a senior attorney has developed over the course of his or her career, the goodwill of a senior attorney's law practice, the subject matter knowledge that the senior attorney and his or her firm have developed over the course of their careers, and the digital value, especially post 2020, the digital value that the firm continues to develop. The second item on the checklist is who do we sell our law practice to, an internal or an external sale? And here there are three options for selling a law firm. The preferred option that we recommend is to join a growing law firm. That is an external sale. Growing law firms, they're looking for what senior attorneys have. Senior attorneys have clients, they have referral sources, goodwill, subject matter knowledge, and that digital value that they're beginning to develop more and more of post 2020. The potential option is structure an internal succession plan. The problem with an internal plan is that for those lawyers that have junior partners, senior associates, partners that have practiced with them for many years, or those that look to recruit attorneys into their firms, often an internal successor, they don't want to purchase your practice and they can't afford to either. And the third option is simply to maintain the status quo. But we consider that the risky option because just because we assume that today is going to be like yesterday and that tomorrow is going to be like today, a random Tuesday event or some other change can happen that can risk the value of the practice. We, of course, are coming out of the COVID experience. And for many attorneys, that was a random Tuesday event. Their practices changed significantly. Some lost significant value. That loss in value can happen when a key employee leaves, or God forbid, if a senior attorney becomes sick, either a mental disability or a physical disability or a premature death. The third item on the checklist is the purchase price. How much is someone going to actually pay me or pay my law firm for what it is worth? And here we divide law firm sales into two parts. That is law firm sales 1.0. The purchase price there is based upon an earn-out price because the primary value components are the book of business, the client list, and the referral source list. And because a buyer just doesn't know, and certainly a bank cannot lend upon whether those clients and referral sources will continue after the sale, buyers are typically paying based upon an earn out on will clients, previous clients, and new clients, will they continue to come to the buying firm after the sale, and they are agreeing to fee share with senior attorneys over a negotiated period of time, a percentage of the revenues that come in from that book of business. In law firm sales 2.0, what we're starting to see post 2020, we're adding in here in the primary value components, the digital value and brand awareness. Now that we are in the 3.0 digital era for law firms, and law firms are starting to brand themselves, they're starting to market themselves in multi-channel digital media ways. As a result, clients have begun to come to law firms because of the brand value that a firm presents, as compared to because they know that such and such attorney is the best T&E attorney or best PI attorney in the marketplace. A large national example of this, of course, is Morgan & Morgan. They are in our face. We are often seeing the Morgan advertising. There is certainly significant brand value when it comes to firms like Morgan & Morgan, and there'll be more firms like Morgan & Morgan going forward. The next item on the checklist is the role of the senior attorney post-sale. when senior attorneys sell their law practices, they really need to continue to have a role in the practice. And what we call here is the trust transfer. Senior attorneys have developed significant trust among their clients over the course of their careers. And the role of senior attorneys involves transferring the trust of their clients to the attorneys and the law firms that they join. This trust transfer is really what we call the flux capacitor of the senior attorney match model, because it's incredibly important for the purchase or the sale to work to transfer that trust of the senior attorney to the client to the attorneys at the firms that senior attorneys join. The next item on the checklist is the client files. That is, what are the logistics involved with those files that senior attorneys and their firms have developed over the course of their careers? And here, what we're negotiating often for our clients comes down to three categories: the open files, the recently closed files, and the closed files. These are always negotiated in deals, and what the buyers are often looking for is for those closed files for the senior attorneys to hold on to those files. They're often not part of the deals. There is a key four-letter word here for the senior attorneys to please take the advice on, which is scan. For as much as you can scan your files now, it's going to make the logistics of selling your law practice later much easier. The next item on the checklist is your malpractice insurance. The key part of the malpractice insurance policy that you should consider when considering selling your law practice are the tail policy terms. It's called the extended reporting period in your policy, the ERP. It's a significant cost. That tail policy often ranges in cost between a 1.75x to a 2.5x of your current year's policy premium. It's important to know how much that would cost, and that cost is set on an annual basis when you renew your policy. And the last item on the checklist for the logistics involved with selling your law practice is whether to involve an intermediary or to pursue a sale as a for sale by owner. Similar to advising a client of yours selling their business, or similar to you selling your house, we're certainly recommending involve an intermediary, learn about the value of your practice, learn about the options that you have when considering to sell your law practice. And now for a preview. For the next in the series on the three checklists to review before selling a law practice, the next in 7 minutes we'll focus on now is the right time to sell because ... And those ... consist of 5 items on this checklist. The first is, well, because there's a low probability of selling to your internal successor. The second is that growth by acquisition has arrived to the legal industry. Growing law firms, they want and need your practice. The third is, especially post-COVID, senior attorneys, they want to spend more time outside of the office. The fourth item is that you may not be generating as much new business as yesteryear. And here is a preview to the preview, is that the legal industry is becoming Uberized. The 3.0 digital era for law firms, where firms are now marketing in multiple ways, and clients have moved to Google to search for their lawyers. Often we're seeing that senior attorneys are not generating as much business as yesteryear. And the last item on that checklist is the upcoming lease renewal. Do you really want to renew your lease for another 3 years or 5 years or longer, or is this the right time to sell your law practice? And that is today's state of the market for law firm sales in a bit more than 7 minutes.